is Wednesday, June 9th, 2022. The time is 6:06 p.m. Apologize for the late start. Officially calling this meeting to order.
Mic's not on. Sorry, your mic's not on.
Oh, sorry, my mic wasn't on. Okay, officially calling the meeting to order. Attending remotely is Commissioner Leslie Duncan, and I'm Commissioner Chris Filios. Commissioner Bill Brooks is hopefully going to be joining us soon, but for now, we do have a quorum with the two of us present. And I'm going to ask Ben, would you please lead us in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay. Do we have any potential conflicts of interest? Hearing none? Okay.
No.
Okay. All right then. So before we proceed to the reconsideration, let me point a couple things out. So is anybody speaking on behalf of a group? No. Okay. So basically what will happen is our first speaker, which is the appellant, that is to say, the individual or individuals who requested for this particular hearing, will get 10 minutes. Everybody else in support will follow that. And that will be 3 minutes, and it will be strictly enforced. And if I hear repeated comments of the same nature, I will ask you to stop. Because regurgitating everything over and over again, we're looking for new information. We already have data that's come up before us, but we're looking for new information. We'll do the best we can. But if I feel there's too much repetition, I'm going to cut it short. Okay, secondly, and then that'll be followed by the representative for Gaza, who's speaking on behalf of Gaza. That'll be 10 minutes as well. And then actually, is that where you come in, David? Where the county, no, the county makes its case.
The appellant, and then anyone who supported the appellant, which I should explain, the appellant.
Why don't we let Vlad take it? Or you want to go?
Well, let me just mention a few quick things.
Go right ahead.
Because you were listing things right out of the Land Use and Development Code, but you stopped short. The testimony from in this case, the appellant is actually Bev Twillman et al.
That's correct.
Which is a reversal of what's normal. Usually the appellant or the applicant would be Gaza.
Right.
So for everyone's benefit, again, tonight, we're considering the appellant and the applicant to be Bev Twillman and others who actually asked for this reconsideration.
Correct.
So they get to speak right after the opening remarks, which is now in with Vlad. And then after that, the county makes its case in chief, and that will be Vlad in particular. And then anyone in support of the county, which is presumably in this case Gaza and their legal counsel and so on. And then the appellant gets the opportunity at the end for rebuttal. Does that answer your question?
Yes, it does. So the appellant, that's right. So the appellant's rebuttal will be 10 minutes, just as the representative for Gaza will be taking 10 minutes as well. Everybody else that's testifying will be limited to 3 minutes. Fair enough?
Chairman's prerogative.
Okay. And by the way, we will not be deliberating this evening. The decision will not be made tonight. We will schedule a time during the day next week. And obviously, the deliberations are among the three of us, and you'll be notified of that. Okay, so David, where do we go from here?
I'd like to just mention a couple of high-level things and then turn it over to Vlad for the opening remarks. And then Vlad's main testimony will come later under item 4. But I would just like to point out that under 8.8.502 of the Land Use and Development Code, these requests for reconsiderations shall be limited to the grounds set forth in section 67-6335 of Idaho Code. The reason that's important is when you turn to the grounds of that section of the code, the Idaho Code, you find that it's really not till you get to paragraph 2, subparagraph B, one sentence in that law, which says expressly, written request in a case like this must identify specific deficiencies in the decision for which reconsideration is sought. So those are the grounds under code on the state level that this hearing tonight really shall focus on in order to deal with what's before you. To me, that means that you need to focus on any deficiencies of your past decision, meaning wrong or incomplete information somehow lacking necessary elements to your decision. So unless that sort of thing is brought forward, then it seems to me your decision is easy, that there's nothing new and your previous decision should stand.
Which decision?
The last,
Please.
if I may answer.
Yeah, go right ahead, please.
The decision you made as a board last.
Fair enough.
So with that, if it's okay, I'd like for Vlad to just touch on a few more things
Yes,
in
please.
case he wants to, as our county opening statement.
Go right ahead, Vlad, please.
Good evening, Commissioners. For the record, Vlad Finkel with Kootenai County Community Development. I don't think I need to reiterate the course of proceedings for tonight, but I'd like to clarify something into the record. While reviewing the public comments that we received for this reconsideration tonight, we received a total of 25 comments. Now, based on review of those comments, I tend to agree with Director Callahan's position is that there's been some confusion because the roles reversed, and some of the comments that were submitted stated that we did not support the applicant's request, one of which was the applicant for tonight's hearing, the appellant.
Right.
And I don't know if I should mention the name, but it's part of the record, Bev Twillman. So I want to clarify if there's been any mistake made by staff in our presentation that's going to be presented later on tonight with regard to the total number of folks in support of the appellant or in opposition of the appellant, please forgive me because it's been rather difficult to make that conclusion. In the future, we will, for reconsiderations, change out the wording from applicant to appellant. And so the applicant will remain with their original request and the appellant will be the individual seeking the reconsideration meeting. In addition to that, I don't know if you need me to introduce anything else. I will be doing a PowerPoint, and at this point, I'll just sit at my desk and you can proceed with the appellant's case.
Okay, thank you. Director Callahan, anything further?
Nothing further at this time. Thank you, Commissioner.
Okay, so the appellant, right,
Right.
tonight will be led by Bev Twillman. Go ahead, right ahead, Bev, you've got 10 minutes.
Now I'm really confused, but we'll try to get through this.
We've got it organized, I think we're okay.
Okay, so you do understand we're in the positions that we're in, and I'm sorry about the mistake and the confusion.
No, we're good, we're fine.
Yes, I agree with you that we need to focus in on new information and not the old information. One of the confusions started obviously with the last hearing. And I don't want to go over that again, but I do want it in the record that the public feels like their communication with the legal department of the county was left hanging, and they kept giving us reasons why what happened was allowed, when in reality, we did all the checking and all the research, and then we actually discovered what they told us was incorrect. Robert's Rules of Order do not allow the minor vote of a vote to make that request for reconsideration. So, as far as all the things you're already familiar with, I'm not going to go back over that. What has been happening is this particular company doesn't seem to pay much attention to the rules, regulations, and ordinances of Kootenai County. When we call for the enforcement of different things, and I know that the parcel in question has been worked on. I've got pictures that I will leave with you. There's work actually taking place as we speak, and this hasn't even been decided yet. I do know there was a stop work order put on that particular parcel because it was working without a permit. I do realize that there are many other issues that Gaza is ignoring and going forward with pretty much in your face. And talking with your own enforcement department, they tell us that there's so many infractions at Gaza that they can't even keep up with it. But they expect us, the citizens, to always have to call on the same things over and over and over for them to come out. And honestly, they said, quote, "We can't keep up with it." Talk to them. I'm not going to use names, but you talk to your own enforcement and talk to them about what's going on out there. I know there's been blasting that has damaged vehicles. I travel Gaza Road, and if I had been traveling down that road when that one blast took place that damaged 40 cars and put holes in roofs, I would have been damaged. So I think working on the land that's in question and giving only minor fines is a cost of doing business in their mind. Our fines, I don't know how to get them higher, but we need to be able to get these people to follow the rules. The lake continues, and I see this so much when this hard rains come, just last weekend and once maybe tonight and tomorrow. You see this in continual runoff. That whole area up there is becoming concrete. That was a natural filtration system for our lake. You're on the committee. You know the lake's in trouble. Let's do something positive to help our lake, not keep allowing these continued growth. I don't like the fact that I feel like some of the public officials that I count on, that I have voted in or I support or my taxes pay their salaries, seems to turn the other way when things happen. I'm not accusing anybody of anything other than it just seems like the state level is where I'm as concerned as anything. And that's not in your purview, I understand that. But we do have to work together. And words and encouragement from our local level gets our state people to pay more attention to infractions, to concerns, and all of the other issues that are taking place. Gaza has, and I'm not going to get into it, somebody else will, been destructive to other places in this western area, and I've got articles to prove it. Somebody else is going to talk about that. They're also serving liquor without a liquor license. I find that offensive. That's not your purview either, but that's just one more thing that they're doing. Since the last hearing, I made a personal complaint to our state liquor board about this, and I've heard nothing. They didn't even respond, the courtesy to respond back saying they had received it. According to people who live up there and work up there, they're serving minors. And these are our local people. Some of them are employees that are minors that are being served. And this is hearsay, I understand that. But when you've got locals that are telling me that this is happening, and they're afraid to come forth, many of them. Maybe some will speak tonight, I don't know. But I feel like we really need to protect our community in lots of ways, and this is not happening. These people don't care about following any of our rules that we follow. They don't care about the destruction and it's not the people. It's the company that's being the people may be perfectly fine. I don't know very many of them, but I'm just saying this kind of a development doesn't belong here. It belongs in LA. And if you have any questions, I'd be glad to answer them. I do have these pictures I would like to insert.
I'll enter those as B 1001.
No, just give me one, that's fine.
Glad I will give you.
Okay. Thank you, Bev. Leslie, do you have any questions for Bev?
I do not, thank you.
Okay. Thanks, Bev. Okay, so moving on, most of the folks indicated opposed, but I think we understand that means that you're in favor of the appellant, in this case, the presentation that Bev just gave. Okay, so let's start with Carlene Cada. Carlene, you're in favor, you wish to speak?
I'll pass.
You'll pass, okay. Jeff Brown, in favor, but does not wish to speak. Now, when I say in favor, you're agreeing with Bev Twillman, is that correct? Yes. Okay, just want to be sure. Okay. Lisa Brown, also in favor? In support, okay. Myra Riga? Okay, does not wish to speak, but you're in favor with Bev. Sue Ann Harns? Does not wish to speak, is that correct? Okay. It's Hannah, am I saying it right, Sakui? Is it SAKWI?
Yeah.
Okay, Sakwi? Okay. Does not wish to speak, is that correct?
I said opposed.
Yeah, you're opposed, yeah, yeah. Brad Jobs? Okay, you're also opposed, but does not wish to speak, okay. Bill Lampard, Bill? Is he here? No. Okay, you do not wish to speak, okay. Also opposed, that is to say, yeah, I understand, you're in favor of the position stated by Bev Twillman. We're okay. Stephen Lyon, excuse me. Okay, opposed? Does not wish to, when I say opposed, obviously you know where I'm coming from. I'm saying opposed because that's what you indicated, but that means you're in favor of the appellant, which is the case presented by Bev Twillman, okay?
Oh, well, in that case, you're reading people that you shouldn't be bringing up now, because they,
Say that again?
if the audience that you just heard from is opposed to Bev Twillman's position, then they need to wait and follow, you need to be reading them in behind the county's presentation.
So what's happening is we've got them mixed up here.
Sounds like it.
Okay, all right, let's back up. I hope everybody checked these. Go ahead, Pat.
Yeah, Chris and David. I think you can go ahead and read off the names now, but just if they do express that they are
Yes, okay.
support Gaza Ranch's position, then you would defer, and they want to speak, then you would defer them until after Gaza and the county give their case. But otherwise, I don't see a problem just reading the names in.
Okay.
Okay, so let me read them off right again quickly. Okay, so Carlene Cada, you are in favor, that is to say, you're in favor with Bev. Okay, so when I say in favor, that means you're in support of the appellant, which is Bev Twillman, in the position that she indicated. Okay, Jeff Brown, same thing? In favor. Yes. Okay. Lisa Brown, same. Got it. Myra Riga? Okay. Okay, so Sue Ann Harns, you're in favor of the Gaza position? No.
In favor of that.
Okay, so that has to be changed.
Okay.
Okay. So Hannah Sakwi?
Yeah, opposed.
Okay, so you're opposed to, okay. So this goes in a separate category.
Okay.
This one is for Gaza. Okay. So Brad Jobs, Gaza? Yes? That makes it easier. Bill Lampard, Bev? Makes it easier, folks. Okay. Okay, that's Bev.
That's Bev.
Stephen Lynn? Gaza. Indicated opposed. Thank you for that. Okay, so all right, that didn't take too long. Okay.
There were more people.
Yeah, there are more, yeah.
Yeah.
We're getting through it now. Daniel Adelson? Opposed.
So Gaza.
Gaza, okay. Barbara Durrell, opposed, Gaza?
Yeah, in favor of Bev.
Bev, okay.
Okay.
Bev, we need to change that.
Yep.
Okay. Jackie McNamara, you're with Bev. So that would be in favor, right? Mm-hmm. And obviously, we have Bev. That should be in favor as well.
Yep.
Janet Torline, Bev?
Yes, the appellant, and I believe I checked opposed, but I am in favor of the appellant.
Yep, we're good. Wish to speak? Stephanie Blell,
I wish to speak.
Okay.
come forward. Okay, Janet, come on.
Okay.
If I missed anybody that wanted to speak who is with Bev, let me know if I have already called your name. Go right ahead, Janet.
Yes, in reference to the defiances on the decision in the Idaho Code, at the last hearing, when the vote was taken to not allow this expansion, Commissioner Duncan interrupted, changed the dialogue, and said that if it wasn't, this piece of property could be developed and 100 homes could be put on it. That is clearly speculative, and it would have meant a separate PUD and probably a CUP, none of which was discussed, so that is a defiance on that decision. Also, in terms of Discovery, they are not good neighbors. They have been sued over in Yellowstone and Big Sky for polluting the Gallatin and Madison rivers by using treated sewage, by leaking sewage lagoons and using over-irrigated, nitrogen-filled fertilizer water from the golf course, which is then put onto it. So there's a lot of water pollution going on. They actually unfortunately lost in court, and now those citizens are putting together a citizens initiative to be able to make them accountable for this pollution. The same thing is happening with North Kootenai and water. Their sewage is leaking. It's leaking into Arrow Point. Squaw Bay is completely brown from runoff. There is now moss and algae in Arrow Point and along the shoreline there. They are irresponsible neighbors. And I realize that North Kootenai is not your purview either, and there's basically no oversight there. So I will be contacting DEQ about that situation. It's untenable. And again, the no enforcements and North Kootenai wanting more water, and they're already drawing close to 2 million gallons of water out of our public waters, our commons. So how much more do they want, and what are they going to leave in their wake?
Thank you, Janet. If anyone else is in support of the position that Bev has taken and wanted to speak, and I've not called you, come right up, Jackie.
Don't have to say my name. I'm one of the people on the shoreline that now has green slime on the rocks, and that is from the nitrogen that leaches down from the fertilized golf course. This wasn't the case a couple of years ago, but it has finally reached its capacity. And yes, we all have green slime, algae at our shorelines. Beyond that, I want to talk about visionary. We are saying that this is a small addition to the PUD, but your job is to be visionary and look at the growth in the long term. And if you look at the provision, which is number 4 in North Kootenai's agreement, which was a moratorium, it was a moratorium that could be lifted at any point. The moratorium seeks to increase water to Geyser. That's the purpose of the 4th provision, to be constantly looking for ways to increase water to Geyser for expansion. It says it right there. So if we are ignoring the vision of them expanding and needing more water, polluting more, then you're not doing your job. Because 20 years from now, you're not going to be here, but our grandkids are going to be here, our kids are going to be here, and it was your job to control this, and it's not under control whatsoever. And I already stated personally that I've had my rate increase. I have a 20-year bond now that I'm living with because Geyser needed more water. I didn't need more water, but my water rates have doubled. And by you not being visionary to say that there's 28 acres here, there's 50 acres there, there's Squaw Bay here, they're all going to need water, they all need sewage. And for you to say somebody else is going to handle this, guess what? It falls on the local property owner who's in the PUD, and to ignore that is to ignore your responsibility. And that's just not fair. And we shouldn't have to expect that. We expect better from you.
Okay. Thank you, Jackie. Leslie, any questions?
Nope, none at this time. I'll jump in if I have questions, so you don't need to ask.
Okay, good enough. Okay, Stephanie Blaylock, opposed? Okay, so you're with Geyser. Okay. Sandy Young, same, opposed? Rob Corrett? Okay. Yeah, okay, they'll be speaking potentially later. Michaela, is it Kepco?
It's Geyser.
Okay. Cheyenne Kramer?
Geyser.
Norb with Bev, opposed with Bev. Myra Sherman?
Yes. Favor Bill.
Okay, so she's right, she's with Bev. Rich, I can't quite spell the last name, starting with an H. It looks,
Mine, Gazer,
okay. 200 Northwest Boulevard,
700.
700, okay. Cameron Norwood? Mardell Thomas? Annie McGrath? Megan, is it Coretta? Okay. K.C. McLaughlin? Tom Finley? Jesse Stolberger?
The ranch, Gaza.
Whitney Stolberger. Stolbarger. Okay. And of course, we have Doug Marcus. That one's obvious. Okay. So I guess, David, I'll turn it over to you now for the county position.
For anything that the county wants to make. And I've actually said everything I want to say, but Vlad is fully prepared and would like to go through a PowerPoint at this time.
Go ahead, Vlad, please.
Commissioners, before I get into my presentation, I'd like to state that Director Callahan and I had communication regarding tonight's presentation, and we wanted to disclose typically when we present at a public hearing, whether it's for hearing examiner or the board, our obligation is to introduce evidence into the record or new information into the record that would assist the decision makers in their ultimate decision on a case. In this case, while I understand that we are here tonight because of the reconsideration request, we as staff frankly don't have any additional information to add that would either support the elected officials' previous decision made in April of this year, or somehow dispute the appellant's request for reconsideration.
Okay.
So I'm going to go through this brief presentation. It's the same one we had last time when we were here. If you want me to move forward to something rather quickly, let me know, but I'll be very brief. Just a second. So the request in this case consists of two different components. The first component is to combine one of the existing residential lots that's adjoining a golf course in order to convert the existing residence, or I believe in this case it may have been partially removed or fully removed, and convert the area into utilize it as a med spa facility and a clubhouse. So that's the first aspect of this request. The second request is, of course, to add 3 additional parcels. One is on the west side of the PUD, as well as 2 on the east side of the PUD. And the sum of the parcels in question would be approximately 28 acres in size. This original project was approved with 662 acres in 2004. In 2018 and 2020, under the direction and approval of Director Callahan, the applicant was able to get a minor amendment to include approximately 2 acres of additional land that was abutting the boundaries of the PUD.
Okay.
And then the latest request is, of course, the 28 acres, which that comprises of the 3 parcels. In essence, the total number of, or the total acreage of the PUD would add up to 692. The approved density in 2004 was 375 units. At this point, there were at least 335 lots platted to account, each lot would account for 1 density unit. Whether or not it's constructed at this time or it's vacant, it's irrelevant. It's the fact that the units have already been allocated to those 335 lots, which means that you have 40 remaining units that are to be exercised to the total sum of what was originally approved. Now, of course, as you know, we do have a provision in our code that allows for consolidation of lots, and there have been a number that were consolidated, but we keep track of that, and there could be 1, 2 plus minus lots, but we have a density chart with each and every plat that is submitted within the PUD to account for that, as well as the list of BLAs. I'm sorry, not BLAs, lot consolidations. So approximately 40 remaining units to be exercised. The density of the proposed lots or parcels in this question on the east side of the, I'm sorry, I can't see, is Ben, is the property on the west side, is that rural or is that restricted residential as well? So all 3 parcels in this case are in restricted residential zone. Each one of them, if they're outside of the PUD, have the density of 5 dwellings per acre. The comp plan designation for the parcel on the west side of the PUD is shoreline, and it's country on the east side. During the agency comment period, we have a list of agencies on the screen that we solicited comments from, and a majority of them were not opposed or had any concerns or any requirements. One of the agencies that did state they would not issue any additional hookups outside of what was approved for the PUD was the Kootenai County North Kootenai Water and Sewer District. And basically what they said is if this property is annexed or becomes part of the PUD, then the applicant will be required to spread the remaining density across those 28 acres and other remaining open land in the PUD, and they would not be allowed to request any additional hookups. So only 40 remaining density units are eligible for connection, regardless of where they are, whether they're in one portion of the PUD, whether it's north, south, east, or west. It's irrelevant. But in this case, if they were to have the 28 acres become part of the PUD, then that density would spread out across those parcels as well. During the first public...
Quick question. So basically, they're limited to 40 additional hookups.
40 additional hookups, regardless of what the overall geographical area of the PUD is, whether it's the original 662 acres or 692 with the 2 acres that are part of the 2 minor amendments and the 28 that are part of this request.
So if the PUD were approved and they took or created 5 hookups, it's 40 minus 5 that remain.
Correct. So you would count against what is still remaining under the original approval. So the point that I'd like to make is that this expansion is to encompass additional land into the geographical area. It's not to create additional density.
Understood.
That has been brought up by the public on numerous occasions when we have gone through 2 or 3, in this case, public comment periods. This argument has been made that this is going to create additional density. It's going to create additional impact to the road system, as well as the resources that the county has provided, or the agencies that provide those services. That is not the case.
Understood.
Could that happen in the future? Anything is possible, but we are obligated to review each and every case on its merits.
Okay.
We can't speculate whether something may or may not occur and then make our findings on that speculation.
Okay.
We have to go off of what the record is.
Proceed. Go ahead, please.
So during the first public comment period for the hearing examiner's hearing, we got a total of 11 comments in support of the application, 12 in opposition of the application. When the appellant requested a public hearing in front of the board, there were 8 in support of the application and 19 in opposition of this expansion. Of course, the concerns were with regard to increase in density, dilapidated road conditions in the area, increase in traffic and noise, provision of water and sewer services that are provided by North Kootenai Water, strain on limited rural infrastructure, I'm assuming that's roads and water and sewer, impacts to wildlife. Based on staff's position, and while we acknowledge the concerns raised by the public, I'd like to reiterate again, there is no increase in density. And that the 28 acres that are part of this request is approximately 4% of the total acreage that was approved for this PUD in 2004, 4%. I'd like to add that this discussion was brought up at one of our project review meetings way before this application was formally submitted. We as staff discussed whether or not this application even rises to the level of a major modification, because it's only 4% increase in overall area, but it's not increase in density. We concluded that it would be prudent to have the board make that decision, because we felt that 28 acres could be considered by some folks as significant change, while it's only 4% or proportionally wise. Therefore, we believe that it's insignificant. The request is insignificant, and the applicant should be approved, and they should comply with the conditions of approval. There are very few conditions, if any, because it's a formality to increase the area, but any subsequent subdivisions that would have to utilize the remaining density would be reviewed at a different date through a different review process, whether it's a minor or a major subdivision process. We believe that the applicant, like I said, should be approved, and that if they are approved, they have up to a year to file a final plan for the PUD. So this is preliminary approval of the expansion, and they have up to a year to file a final plan. The hearing examiner heard this request on January 20th of this year and subsequently recommended approval. So then that brings us to the hearing that was held by the board. It was conducted on March 24th of this year, and the board signed the decision approving this request on April 14th. However, between the approval date and the signing of the decision, the appellant, in this case, requested a reconsideration before a formal decision was signed. So the chronology is a little bit out of the order, but that's okay. I just want to explain that the reconsideration request was brought forth before the decision formally was signed. And then during the third public comment period for tonight's hearing, it's my interpretation of what was submitted that 21 individuals supported the appellant in this case, and 4 were in opposition of the appellant's request and supported the Gosda Ranch HOA. And that brings me to the end of my presentation. I stand for any questions that you have.
Okay. I don't have any. That was well done. Good summary. Thank you, Vlad. Okay, so David, what I see here is people that might want to testify for the county.
Yes, sir.
But in essence, did we not already do that?
No, you still have any of the Gosser people that would like to.
Oh, that's a good point. Okay, so why don't we start with Attorney Doug Marfus? 10 minutes, sir.
Good evening, Commissioner Filios, Commissioner Duncan. You see me, I don't see you. Thank you for your time this evening. I will be very brief. Being the lawyer has to do what lawyers do in these things, and that is to direct, to the extent necessary, what the legalities of this request for reconsideration entail. And Mr. Callahan touched on that in reference to his opening remarks, that under Section 8.8.502, request for reconsideration in the county's rules, it specifically incorporates by reference Idaho Code Section 67-6535, and states that requests for reconsideration shall, and that's stern language, as you know, when it's found in an ordinance or code, requests for reconsideration shall be limited to the grounds set forth in 676535 Idaho Code. Turning to that section of Idaho Code, Director Callahan quoted a portion of it, and I would encourage the board to review that at the time of your deliberations in writing. But I'll summarize that subsection 3 of Idaho Code 676535 sets forth the legislative intent and goes on, and this is very critical, so I'm going to read this into the record. It states, and I quote, "Only those whose challenge to a decision demonstrates actual harm or violation of fundamental rights, not the mere possibility thereof, shall be entitled to a remedy or reversal of a decision." What the applicant, Ms. Twellman, is requesting here is a reversal of the decision made at the last hearing. The decision made at the last hearing was demonstratively correct. It was the right decision for a variety of reasons, most of which were well summarized by Mr. Finkel. Under this code provision, which you shall follow, only those challenges which demonstrate actual harm or a violation of fundamental rights shall justify overturning that decision. And the legislative policy there is pretty clear cut. It's so that you poor public servants don't have to go through this over and over and over based upon repetitive requests for reconsideration. You got the right answer last time. You simply need to deliberate again because there is no demonstration in Ms. Twellman's presentation or anything in the public comments that demonstrates a fundamental violation of fundamental rights or actual harm. Now, there's a lot of concerns expressed. There's a lot of worry about water quality, about the environment, about construction, about too many people moving here, too many people living here. All those things are legitimate concerns, but they are not demonstrable harms that justify reversal of this decision. So unless you have any further questions, I will yield to the next speaker.
I have none.
Thank you, sir.
Thank you. Okay, I'll make this, mix this up a little bit. Stephanie, did you want to speak?
I'm gonna let Sandy go first.
Sandy?
Sandy Young, for the record, 3906 North Schreiber Way. Only want to say we heard the testimony of those in support of the overturning of the decision. Again, I know you've heard this before, and Chairman, I apologize, and also Commissioner Duncan, but the offer is to expand open space by 28 acres. It's not algae, it's not water quality, it's not slime on rocks. We didn't hear one public agency voice any concerns. The county's in support. The hearing examiner was in support. You were in support the first time, signed that order of decision, and I appreciate that decision and ask you to make that same one again. Thank you.
Thank you. Okay, so I'll go through those who are opposed, that is to say in favor of the Gosser position. Whitney Stolbarger, did you wish to speak? No, okay. Jesse?
No, thank you.
Okay. Tom Finley? K.C. McLaughlin? Megan Coretta?
No, thank you.
Annie McGrath? Mardell Thomas? Cameron Norwood?
No, thank you.
Rich?
Thank you. I'd just like to voice my support for the points made by Attorney Marfis and Ms. Young.
Okay. Is that it? Okay. Cheyenne Kramer?
No, thank you.
Michaela Klacko?
No, thank you.
Rob Coretta?
Yes, please.
Come forward.
Rob Corrett, 1880
Oh, it's
East.
correct, sorry.
Correct, 1880 East Canfield Avenue, Dalton Gardens. I just wanted to point out the appellant made a very important note that, we're here to follow the rules, which is exactly what we're doing. So we're in the process of a PUD amendment. We are in the process of not increasing density. We have, as Vlad correctly pointed out, followed the rules with regards to the number of water hookups allowed, and that is something that continues. We also concur with the commissioner's previous vote, and it is not our intention, nor do we intend to increase density. And I think that that is something that needs to be considered during this vote.
Okay,
Thank you.
thank you. Stephanie? Okay. Daniel Adelson? Stephen Lyon? Brad Jobs? Hannah Sakwi? That's it? Okay. Bev, you've got 10 minutes to rebut.
No, this is not about density. It never was about density. Gaza was given X amount of acreage in their initial PUD because they built probably bigger homes than they initially anticipated. I don't know why. They've run out of space to utilize the number of homes that they were, a number of hookups, let me put it that way, that they were allowed, water hookups. So they have 40 water hookups left, correct. This is not about density. This is about continued construction, continued destruction of land that is important, not only to the rural community, but to the health of the lake. Traffic is a problem without any additional homes. It's the construction traffic. It isn't additional people. Gaza people are not here, but part of the year. That's not who we're talking about. The construction traffic is what the increase to allow more acreage to be built on allows for more construction traffic. If they build out their initial acreage and they aren't given any additional acreage, that construction traffic will eventually stop. But to continually allow more acreage because the homes are getting bigger, yes, it's one more hookup, but it's a much bigger home than maybe initially was put in. So that's the point. This is not about the density. It's about all the issues that by taking more land and making it part of this. I would also like to point out the majority, I don't know that, you aren't reading addresses, so I'm not really positive. I would venture to say that everybody who is wanting to see this approved, none of them live here full-time. Your constituents and the people that suffer the most are the people that live here full-time, the people that drive Highway 97, the people that need their wells to remain intact and healthy. Yes, green slime sounds like something minor, but it isn't to the people who don't have water to drink. And apparently down at Arrow Point, most people have been told they can't even drink their water anymore. These are issues that come with overdevelopment. So why give more land the opportunity to be developed? And I'll go back to the original hearing. The original decision was 2-1 against allowing this. And then all sorts of confusion ensued because Mr. Braden suggested a reconsideration. Commissioner Duncan asked for a reconsideration when in reality she was the minority vote and should not have been allowed to make that appeal. And things got really confusing then. And because of the confusion, another vote was taken, but the vote was changed. The original vote denied this. So I don't like that being ignored. And I really do feel because of the confusion, because of what took place, and I don't think there's a legality or non-legality because of the procedural breakdown with the minority vote making that request for a reconsideration. That was not allowed by any rule that we can find or Robert's Rules of Orders or anything. But it was allowed. It went through. So we had to accept it. We didn't scream, we didn't yell. We've kind of gone through this process. I'm sorry we're here again, but let me tell you something. We paid, the citizens paid for this hearing, not Gazer. Yes, it took our time, and they're having to pay Ms. Young and some of these other people. I understand that. But we citizens are paying to try to see this done correctly. So I just want to emphasize the fact this is not about density. This is about the continuation of the destruction of land that's important to not, the wildlife might not be important to Veritas or whatever Sandy's business is, but it is important to wildlife, and it's important to us that live there full time. Nobody here, besides those who spoke against seeing this thing through, live here full time. I would just venture, and you might ask, I'd be curious, if they do good, then they have a right to want to see that grow too. It just felt like there were deficiencies in the past hearing. There was interruption that shouldn't have been taken. The process didn't ever seem satisfactory. We appreciate the reconsideration hearing, but again, we've gone through the pain of trying to organize it, trying to get to be heard. So I really think Commissioner Filios's initial vote, if he'd go back and think about why he voted initially to deny this, I think that he should reconsider and go back to that vote. And I would like to insert also this is kind of piggybacking on what Janet Torlane had. This is proof of what Discovery's problems have done up in the Gallatin River area. And I think that's important to insert into the record.
Okay. Yes.
Yeah.
B 1002.
Okay.
And I stand ready for any questions. I'm not here to make a lot of, I'm just trying to put the facts out there.
That's fine. Okay. You're good, you're fine. Okay, so we do have all the names and addresses for the record, because I didn't ask you for your addresses when you came forward, so we do have that. And just in case I forgot to mention it up front, this is PUD 21-0003, which is Gaza Ranch Golf and Lake Club Planned Unit Development. Before we adjourn, Director Callahan, do you have any comments, sir?
Commissioners, in the beginning of Ms. Twellman's opening remarks, she mentioned that code violations exist and that the staff can't keep up. I can tell you that the staff did place a stop work on the code violation with which we became aware. That was work without a building permit. I have evidence in our electronic files that the work was stopped. To my knowledge, it has continuously been stopped, and there has been no new construction work. If it has occurred, we are unaware of it, and no one has complained to us since our stopped work. I hear regularly from my code enforcement officer every morning, so normally I would get that as a briefing if there were an issue.
Okay.
I'm not aware of any other infractions or concerns on the Gaza area at this time.
Okay. So before, again, we adjourn, any more comments from staff? Okay, hearing none. David, we're going to be deliberating next week. How much notice should we give? People are entitled to what, at least 48 hours?
If we can pick the night or the time tonight.
That would help?
We don't actually have to do a notice. It would be to a date certain.
To a date certain?
We can add the deliberations to next Thursday.
Community development update.
Yeah, that might not work for me.
No.
Jonathan, do you have a calendar?
I have the calendar up, Chris.
Do you? What looks good, Leslie?
I do. Well, if the Planning Commission workshop is not going to happen, then we could do it. Actually, no, Thursday is not going to be good at all. David, can we do a different day than Thursday?
You can pick any date that the board's available and the room's available.
All right, let me open the room calendar.
Let me do that too.
Friday afternoon?
It looks like Friday afternoon, the 17th, would work. We could do 1:30 or 2 o'clock if you wanted to do Friday the 17th.
Friday, the 17th. So that would be basically the earliest convenient date.
Yes, the earliest, yes. If you wanted to go into the next week, there is a holiday that week, and so it looks like it'd have to be the afternoon of Friday the 24th, if unless you're available that Thursday the 23rd at 9.
You know what? Let's hold to the 17th. Can we do
Okay.
that? Can we do that at 1 o'clock? Or is 1:30 better?
1:30 is better for me, but yeah, that works.
Okay, so, all right then. So then basically what we're doing is we're continuing, and that will be deliberations. That is Friday, June 17th, 1 week from tomorrow, 1:30 p.m. You need not be here. The deliberation is strictly amongst the three of us. It'll be available via Zoom or on YouTube. You're certainly welcome to attend if you wish. And pretty much that's about it. So, no further comments from staff? I have 7:02, and this meeting is adjourned. Thank you, everyone.